The grand jury's decision in the Eric Garner case reconfirmed for many what they already believed: America's justice system is racially biased. Meanwhile, news that federal authorities have launched an investigation may give some people hope for justice. But many civil rights activists say the federal investigation may be too little too late, as they also raise questions about whether local authorities can conduct a fair hearing in racially charged cases. Gloria Browne-Marshall is an associate professor of constitutional law who is a former civil rights attorney, and she is the author of Race, Law, and American Society, 1607 to Present. She joins us from Washington, D.C. Gloria, hey, it's good to see you. Thanks for being here.
Thank you.
Give us a little bit of a history primer, if you will, on the grand jury. How did it start and what's its purpose?
Well, actually, the grand jury began as a way to make sure that the government was not abusing the trial process by using it as some kind of harassment technique. So the colonists under King George said, of course, if I had my country, I would have some protection against using the trial system as a mechanism for harassment. So they said, we'll have regular people look at the evidence ahead of time and see whether or not it's worthy of actually being used against an individual in a criminal case. So the Fifth Amendment of the U.S. Constitution, within the Bill of Rights, the Fifth Amendment actually specifically states that there must be an indictment or charges brought as a presentment before a person can be tried for a criminal offense. So the grand jury was kind of like a precursor to trial, just to make sure there was enough evidence to actually go to trial. And that's why the grand jury has a probable cause standard, while if the trial actually takes place, the criminal justice standard for finding someone guilty is beyond a reasonable doubt.
So if I understand your explanation, it was very good. The grand juries, are they generally used the way they were originally intended, and how are they used these days?
Well, actually, it was used to protect from the government, and the prosecutor representing the government now uses the grand jury as a type of, tool in order to get that criminal justice verdict of guilty. So basically, they start off in certain cases, not all cases, but in certain cases, they put them through the grand jury process to give it another level of credibility before bringing the case to criminal trial. Now, remember that prosecutor could also have presented charges against the defendant, as they do in other cases. But to add that level of credibility, the prosecutor now uses that grand jury system to put, especially controversial cases involving politicians, police officers, corruption cases such as those would go before the grand jury, murder cases, and then go through the regular criminal justice process. That's why they say that a prosecutor could actually indict a ham sandwich, because the prosecutor is the only one in the room. It's not an adversarial system where the defense counsel is on one side and the prosecutor is on the other. It's only the prosecutor showing the best evidence, seeking an indictment from those grand jurors, and then taking that this indictment into the criminal justice system, saying the people in the community have already said this person has enough evidence against them to be found guilty. Now we're going to go through the whole adversarial process, and that's another level altogether.
And it would seem that in this case that it's difficult to indict a ham sandwich if that ham sandwich happens to be a law enforcement officer. So the grand jury process itself has been called into question with these cases with Michael Brown and Eric Garner. So I guess my question to you is, from where you stand as a judge, do you see a need to tweak, to improve how grand juries are used? And some are even calling for the discontinuation of grand juries. What are your thoughts there?
Well, I clerked for a state court judge. I also clerked for a federal court judge. And I've seen the behind the scenes of the criminal system as well as the civil rights system as a former civil rights attorney. My concern is that we not have a knee-jerk reaction when it comes to this grand jury system, because we did not get what we needed from the system. I think it has a plausible foothold in our jurisprudence. I think it's an important first step. As you said, sometimes it's just a rubber stamp for prosecutors to get what they want, but it's also showing us when a prosecutor is not being vigorous, when a prosecutor is not going after that person. If this had been a police corruption case, that prosecutor would have gone in there with the best evidence possible. The prosecutor would not have just tossed everything on the table and said, hey, grand jurors, you figure it out. No, that's not the way they do. And I think that's what has gotten everyone so upset. It's the fact that there's double standard when it came to a police officer. And so I think we could have the grand jury system, but I think when it comes to these police cases, that we need to have an independent investigator work on police cases, because the prosecutor and the police department work together. They use those police officers to give testimony. The police officers gather evidence in the criminal cases that the prosecutor brings, and now they want that same prosecutor to turn around and say, now we want to indict the police officer we just used 2 weeks ago in our criminal case. They're too close. Mm-hmm. That's why we need that independent prosecutor to come in when it comes to a police case.
And by the way, I just want our viewers to know we've been looking at live video from Lower Manhattan, a protest going on right now, even as we speak, in front of the courthouse. One more quick question before I let you go, Gloria, and that is, can you explain legally why the Eric Garner grand jury did not indict in view of the video and the medical examiner's determination for his cause of death?
Because the majority of them didn't want to. That's what I see. A majority of them didn't want to. You have to think about the environment. You're taking grand jurors from the environment of Staten Island, a conservative borough compared to the other boroughs. And you have so many people within that borough who are related to police officers, who are related to first responders, fire department members. And so you have a very close-knit community. Sometimes the borough of Staten Island believes it's them against the rest of New York City. And I think they just closed in a closed-knit community, and there weren't enough members in that grand jury pool to say we're going to indict this particular officer. And they have that power to do so. Now you have to think, what is the other option? And that's been the civil rights option. You know, the civil rights cases are brought when the states don't protect those rights. And we also have, under international law, the United Nations has said that there's excessive force within the police departments in the United States has risen to the point of criticism by the United Nations Torture Committee. And so they have even proposed an independent investigator when it comes to police cases as something that the United States should follow.
Absolutely. Gloria Browne-Marshall, thank you so much. It was great to talk to you.
Thank you.